Hi, friends. Welcome to Lawyers Info Hub. It's always a pleasure to create content on this platform. Lawyers Info Hub is a platform that has been set up to help young lawyers, law students, even older lawyers to have an easy explanation and easy teaching for ease of understanding about law concepts, legal concepts, practice issues, life of a lawyer, and all that pertains to practicing law. So today we are looking at the issue of non-suits. Non-suits. When you hear about non-suit, what should come to your mind? So I'm going to break it down as simple as it can ever be, so that you can, even when you close your eyes, even when you're sleeping, you can explain what a non-suit is and what it also involves. Now, when parties have finished, trying to prove their matter or case in court, the claimant has done all that is required of it. The defendant has done. Trial has, been concluded, and the court, adjourns for final written address. Now, in the course of trying to, write a judgment, there might be a need for in reviewing that case. The judge might be of the opinion that the claimant and the defendant are not entitled to judgment. Yes. Where the judge is of the belief that neither parties are entitled to judgment. There is something, you know, has happened, or there is a factor that makes it possible for both parties not to be entitled to judgment. And in that wise, it gives the claimant another opportunity, to relitigate that issue. Now, if you find yourself in such situation, what do you do? Now, when the judge is of that, have that belief that neither parties are entitled to judgment, the judge will now request or notify the parties that please address me on this issue of non-suit. Address me on the issue of non-suit. Some other time may not even get to the point of filing of final written address. The court might also raise it to say, in your address, your final written address, make submissions with respect to non-suit. Because most judges, even before judgment, as trial, by the time they've heard the two parties, they might have an idea of where the the where what the real issues are and how to go about it. So just some judges, who have seen ahead, will say, okay, can you address me on issue of non-suit? Now, this is the instance where the judge is raising it. This is where the judge raises it so motu, where the judge raises it on his own accord. There's also instances where a party who is not the claimant, who is stated the suit, maybe a defendant, to say, my lord, non-suit this matter. But it's in rare cases. Most of the times it's the judge that raises the issue of what non-suit. And let me just give you an insight. In the case of Ebuchu against Continental Merchant Bank, it's a 2016 8th Nigerian Weekly Law Report matter at two at page 208. In that case, the court noted that an order for non-suit or of non-suit can be made in the following circumstances. One, where the plaintiff has not failed in total or entirely to prove his or her case. Yes, the claimant or the plaintiff has to prove his case. Not like he did not prove everything, but the judge is of the belief that you're not entitled to this judgment, and also the defendant is not entitled to it. So the court noted that where the plaintiff has not failed in total or entirely, there's some fallout on the part of the plaintiff. There's some fallout on the part of the claimant. They have proved certain points of this case, but some parts, did not prove it. Where the defendant is not in any event also entitled to the judgment of the court. Where no injustice will be done to the defendant, who would be caused, or would be caused by such an order. Now, the third one is where no injustice will be done to the defendant. Yes, the defendant, you're not entitled to this judgment, and there's no injustice that will be done to you if this judgment is not for you. So these are the three instances where the court can order or a non-suit. Now, it is also very important to note that where the court orders parties to address it on the issue of non-suit, parties are now given a date to come before the court to make an address, to make a submission. For the claimant will be making submissions. Peradventure, you find yourself in that situation, being the claimant in that matter. You're going to make submission to the court to say, my lord, don't non-suit. So imagine having to do a case maybe for 6 years, 7 years, and the court is saying I'm non-suiting. The time lost and the value maybe of the case, a lot of things will have gone up because the court is saying, the import is like, when your matter is non-suited, the claimant can still go back to relitigate. So nobody can raise issue of it's not a dismissal. But another challenge could be also on the issue of statute of limitation. The timing with respect to that suit could be issue of land and all of that. So the question now is, you as a claimant, what do you need to do for you to make arguments, submissions with cases on the court to say, my lord, I have proved this case with concrete evidence, and I believe I am entitled to what judgment. Please enter judgment in my favor. The defendant, on the other hand, can also say, my lord, we have been able to defend this suit and judgment should be in our favor. Or sometimes some defendants, what they do in such instances is for them to say, my lord, yes, non-suit this suit for this other reason. Other defendant, depending on the interest in the matter, might say, my lord, non-suit. Some must say enter judgment in our favor because we have been able to, to counter whatever the claimant has been able to say. Now, it's also very imperative. One of the things, as I have seen, as some valid appeal, grounds of appeal in a matter when it goes up on appeal is where the court raises that issue of non-suit that did not invite parties to address it. It affects the right to fair hearing of those what party. So I will also say that in an order of non-suit, say it's a final decision in the sense that it terminates the proceedings in which it is made. You can also see it in that case I noted. The power to make such order is say it is statutory, and the court in exercising it must, ensure it acts judiciously. How will the court act judiciously? By ensuring that the both parties or parties in the suit are heard on that issue before the court can make a decision. So where the court does not give opportunity for the parties to be heard, that means it's not now a judicious exercise of the court's discretion. So you can check other cases there. We have Ayanduba against NRTC is a 1992 5 Nigerian Weekly Law Report Part 243, 535. It's also very important that if the parties are not invited, it affects their right to what fair hearing that is enshrined in Section 36 of the Constitution. So when the judge goes on to make an order for non-suit that does not invite the party, so it can even be the first point you raise in your notice of appeal as your grant of appeal because you have been denied the opportunity to express yourself, to make further arguments on why the court should not non-suit. So it's a violation of the party's right to what fair hearing, where the court raises such issues so motu, makes an order on it without involving the parties. So you can also check the case of Omokuwajo and Federal Republic of Nigeria is a 2013 Nigerian Weekly Law Report, Part 1359300. You can also see the case of Adeleke and Raji, the 2022, is a 2002 13 Nigerian Weekly Law Report, Part 783 at 142 is very, very, very key. Now, with respect to issue of non-suit, every court rule, like the rules of the court, depending on the state you're practicing, there's provision for issue of non-suit. So you can also, when making your address, make reference to that provision of the rule. So as a claimant, as a defendant, how do you approach it? How do you write, or how do you, how do you state your argument? First of all, in making such an argument, I will only advise that, first of all, you start with what a non-suit is. It's more like you're writing a written address. Just that format, put the heading of the parties, you now address it, issue of non-suit, so raised so motu by the Honorable Court, claimant's address or defendant's address, on issue of non-suit raised so motu by the Honorable Court. You let the court know what a non-suit is all about. You let the court know when the court can order a non-suit. You let the court know that it is statutory for the court to invite parties to be heard before an order of non-suit is made. Now you now begin to make arguments. For the claimant, you need to let the court know how you have been able to prove your case. You let the court just do a little summary of your final written address where you have canvassed court already for already on how you have proved your case. Give it. Now, if there are some gray areas or there are some issues that you know that this might be the issue why the court is raising this lawsuit to say, I'm not entitled to judgment, the defendant is not entitled to judgment, you now canvass more points on that issue and urge the court to enter judgment in your favor. Now, if a defendant too, maybe your submission is not for the court to enter an order of non-suit, but your submission is you want judgment to be in your favor. You also note as a defendant, you now make arguments to let the court know why just like a recap of your final written address that the claimant is not entitled to judgment and that the court, you may also pray that the court not to non-suit if you think you're entitled to judgment. But sometimes you see some defendants saying the court should non-suit because one, there is no injustice that will be done to the defendant. So you say no, the court not to non-suit in the original point of view. So when issue of non-suit comes, a very dicey issue. It's especially for the claimant who feels all the stress, all my work, all the trial, all the evidence brought is beginning to look like nothing. So you make strong argument, and in court, when you're given opportunity, you submit succinctly, letting the court know why the matter should not be non-suited. But even peradventure they ends up the court non-suiting the matter, you still have a right to go on appeal on the issue, or look at the issues that the court has raised and made it to non-suit. Look at it critically. You can still go back if there is time. You are within time, or there are no issues of statute of limitation. You can still go back to refile because that matter was not what it. That non-suit order is not a dismissal. You can go back and refile, have a second bite at the cherry, in reinstituting the matter, in refiling and starting all over again. But you choose what is best for you or what you feel will serve the interests of what justice. So non-suit is a concept. There's also, from what I've said so far, you see that the difference between non-suit and order of dismissal, or when a matter is dismissed, where you cannot go back, but under non-suit you can still go back and have a second bite at the cherry. I just hope you understood what non-suit is all about. I see that it is providing the rules of court of any state you're practicing. Just go through the rules and you see it, and what steps you need to take, what is statutory for the court to ensure that even raising this matter, this issue of non-suit so motu, parties must be invited to address the court. And if you're the claimant, what is the argument? If you're the defendant, what is the argument? How do you fight this process? I just hope you learned something today. Do take care of yourself and know that you can always be the best. Take care of yourself and know that keep pushing. A person who is resilient will always meet success on the way. Just stay blessed.